right, apologize about that delay with some technical issues. Can everybody hear me?
Yes, Your Honor. Yes, Your Honor.
All right. My name is Judge Spencer Walsh. Are you Ryan Michael Bate? Date of birth, September 1st, 1992?
Yes, Your Honor.
All right. You're here today for your initial appearance in cases 251100344 and 343. I'm going to read to you the charges that have been filed against you by the state of Utah in these two cases. We'll start first with case 251100344. You've been charged with count 1, attempted aggravated murder, a first-degree felony, in violation of Utah Code 76-5-202. Have a copy of the charging documents called informations there in front of you. Count 2, aggravated murder, a capital offense in violation of Utah Code annotated 76-5-202. Count 3, aggravated murder, a capital offense in violation of Utah Code annotated 76-5-202. Count 4, attempted aggravated murder, a first-degree felony in violation of Utah Code 76-5-202. Count 5, attempted aggravated murder, a first-degree felony in violation of Utah Code 76-5-202. Count 6, attempted aggravated murder, a first-degree felony in violation of Utah Code 76-5-202. Count 7, endangering a police service canine with conduct likely to injure or kill, a third-degree felony in violation of Utah Code 76-13-209 2C. Count 8, possession of incendiary device, a second-degree felony in violation of Utah Code 76-15-210 2A. Count 9, possession of incendiary device, a second-degree felony in violation of Utah Code 76-15-210 2A. Count 10, possession of incendiary device, a second-degree felony in violation of Utah Code 76-15-210 2A. Count 11, possession of a dangerous weapon with criminal intent, a Class A misdemeanor in violation of Utah Code 76-11-208. Count 12, possession of a dangerous weapon with criminal intent, a Class A misdemeanor in violation of Utah Code 76-11-208. Count 13, assault, domestic violence with a prior qualifying offense, a Class A misdemeanor in violation of Utah Code 76-5-102, subsection 2. Count 14, assault, domestic violence with a prior qualifying offense, Class A misdemeanor in violation of Utah Code 76-5-102, sub 2. Count 15, assault, domestic violence with a prior qualifying conviction, a Class A misdemeanor in violation of Utah Code 76-5-102, sub 2. Count 16, unlawful detention, domestic violence with a prior qualifying offense, Class A misdemeanor in violation of Utah Code 76-5-304, 2A. Count 17, threat of violence, domestic violence with a prior, a Class A misdemeanor in violation of Utah Code annotated 76-5-107. Count 18, domestic violence in the presence of a child, a Class B misdemeanor in violation of Utah Code 76-5-114, subsection 2. Count 19, domestic violence in the presence of a child, Class B misdemeanor in violation of Utah Code 76-5-114 sub 2, and count 20, domestic violence in the presence of a child, a Class B misdemeanor, in violation of Utah Code 76-5-114 sub 2. In that charging document before you, there is set forth a probable cause statement, and it has the details of the allegations against you. There's also all of the alleged elements of each of the specific charges that the state has alleged against you, which is set forth in more detail in that information that is set forth in the charging document. In conjunction with case 251100344, the state of Utah has filed a notice of intent to seek the death penalty in accordance with Utah Code 76-5-202 subsection 3A. The state of Utah has filed notice, and you are hereby on notice that they are seeking the death penalty for counts 2 and 3, aggravated murder in violation of Utah Code 76-5-202. Additionally, the state has charged you in case 251100343 with the following. These allegations have a alleged offense date of May 8th, 2024. Count 1, aggravated assault, domestic violence, a third-degree felony in violation of Utah Code 76-5-103 subsection 2. Count 2, domestic violence in the presence of a child, a third-degree felony in violation of Utah Code 76-5-114 2B. Count 3, domestic violence in the presence of a child, third-degree felony in violation of Utah Code 76-5-114 2B. Count 4, domestic violence in the presence of a child, third-degree felony in violation of Utah Code 76-5-114 2B. And lastly, count 5, property damage or destruction, domestic violence with a prior qualifying conviction, Class A misdemeanor in violation of Utah Code 76-6-106.1 2B. The charging document contains a probable cause statement, and the charging document also contains each of the alleged elements for each of the 5 counts. You will be provided with discovery in both of your cases and all affidavits, recordings, and evidence once you request that through yourself or through counsel. You do have the right to be represented by counsel in both of your cases under the Utah and United States Constitutions. If you cannot afford your own attorney, the court will appoint counsel to represent you if you qualify. Mr. Bate, are you seeking to be appointed counsel to represent you in these cases?
Yes, Your Honor.
You're currently in custody, and so you're not able to work. Do you have any assets or property that you could access to be able to retain counsel?
No, Your Honor.
The court finds that you are indigent and that you are entitled to legal representation through appointed counsel. Because case 3 ending in 344 is charged as a capital felony for 2 of those charges, pursuant to Rule 8 of the Utah Rules of Criminal Procedure, you are entitled to counsel that would be selected by the Office of Indigent Defense Services. That would be counsel who would be qualified to handle a capital case here in the state of Utah. Prior to today's hearing, yesterday, the court did reach out to the Office of Indigent Defense Services in anticipation of the possibility that you would be requesting counsel to represent you. And it's my understanding that Jonathan Nish and Mary Corporan have been selected, at least for the time being, from the Office of Indigent Defense Services to represent Mr. Bate. Is that correct, Ms. Corporan and Mr. Nish?
That's correct, Your Honor. Jonathan Nish.
Yes, Your Honor.
Ostensibly for Mr. Bate. We have been approached by the IDC. I have agreed to take on the role of lead counsel, and I have elected Ms. Corporan as my second chair. We'll be filing affidavits with the court of our qualifications pursuant to Rule 8, as well as entries and discovery requests. We'd ask the court to appoint us or orally appoint us now and then sign our documentation when it is presented before the court.
Very well. The court hereby appoints Attorney Jonathan Nish and Attorney Mary Corporan to represent the defendant in this case, and the case ending in 344. Now, he does have another case ending in 343, which is not charged as a capital offense. I'm going to appoint Attorney Logan Bushell to represent the defendant in that case, unless newly appointed counsel here today, Mr. Nish, do you know if you're in a position to determine whether or not, under the rules of the Office of Indigent Defense Services, whether or not you would be in a position to represent him on the other case, which is not a capital offense?
I'm not sure if the IDC contract covers the second case, Your Honor. If that case is going to be trailing, we probably don't have too much of a concern. We will consult with the IDC, and if they will allow us, we will probably want to take control of that case, but we'll consult with the IDC and get back to the court as soon as we have an answer to that.
All right, for the time being then, the court does appoint Attorney Logan Bushell to represent the defendant in the case ending in 343. If at a later point in time, Mr. Nish, you and Ms. Corporan have more information and are in a position to represent the defendant in both cases, let the court know, and then the court would release Mr. Bushell at that time from representing the defendant. All right. The defendant does have rights under the Utah Code and the Utah and United States Constitution. He is entitled to a pretrial detention hearing where his custody status can be addressed. I understand that you do not have discovery yet, Mr. Nish. There currently is an order holding the defendant without bail. There was previously a finding by the court that this is a capital felony and there is substantial evidence to support the charge. And so he's currently being held on a no bail status. Would you like to address his custody status today, or would you like the benefit of getting discovery in the case before addressing that?
Your Honor, we'll defer addressing detention at this point. We'd like to get a copy of the discovery, have some conversations with opposing counsel. We'll let the court know when and if we'd like to set that detention hearing.
Thank you. All right. In addition to some of those other things that the court has addressed, I'm noticing that in the case stemming from alleged offenses from May 8, 2024, the prosecution has filed a request for a pretrial protective order. In that order, in that proposed order, they are seeking an order of protection that would protect the alleged victim in that case. I'll just refer to her by her initials for her privacy. That would be MS. And they are seeking an order that would protect her from any threats or acts of domestic violence, stalking, abuse. They are also listing some children that they are seeking protection from. The initials on those would be DJ, MB, and EB. They're requesting a no contact order that would prohibit the defendant from harassing, telephoning, contacting, or otherwise communicating with the protected parties. And then there's some other details about the defendant and the protective person share custody of one or more minor children. They're requesting an order that the defendant only contact the protected person to arrange visits with children by the options below. And it says in accordance with any ruling from a family court. So essentially, it seems like the state is requesting no contact unless it's approved by the family court. There's also a request that the defendant be prohibited from living at the protected person's residence. And he could get some of his belongings from the residence potentially with appropriate protocols. He's ordered to stay. The request is that he be ordered to stay away from the protected person's residence, school, workplace, etc. And have you had a chance yet to, I know that Mr. Bushell has been appointed in that case, but for the limited purpose of today's hearing where you have been appointed in the case ending in 344, I wanted to address that. Mr. Wardle, you're here today on behalf of the state of Utah. Will you be the prosecutor on this case moving forward?
I'll be on both of the cases.
All right. Anything further that you'd like to add as far as your request? I guess perhaps we need to see if there's any objection by the defense to the court signing off on that pretrial protective order, but anything further that you would like to add?
No, I think it's contained in the protective order.
Mr. Nish?
There's something I'd like to address, Your Honor. Well, it's Mr. Bushell's case, so I got to be careful about standing here. As it comes to my case, at some point in time, and I don't know who these people are yet, I'm sure they'll be identified in discovery in some way. They are likely to become witnesses in some respect in the capital case, whether that be fact witnesses or whether they be mitigation witnesses. I don't object necessarily to the protective order, but I would like the court to add a carve out that members of my team, whether it be the attorneys, my fact investigators, or my mitigation investigators, may make contact with them for purposes of learning about our case and building our mitigation case, and that technically we would be doing so on behalf of our client as we are advocates, that not be construed as a violation. And they don't have to talk to us if they don't want to, but we need the ability to at least approach them.
Okay, so you're requesting some carve-out language to allow the attorneys and investigators on the defense team, but not the defendant
Correct.
himself, to be
Just
able
members.
to reach out and attempt to interview, conduct investigation, and some of these protected persons may be people that need to be interviewed or attempted to be interviewed. Mr. Wardle, your thoughts?
I mean, I understand that. I think that they have their duty and their rights to do that. And as Mr. Nish said, of course, I just want to make clear the court isn't ordering that they have to speak to them, but just that the defense counsel and their people wouldn't be, assisting in violating that order. I understand where they're coming from, and I don't object to that.
And
Yes.
my team is very professional, Your Honor. We know how to make these approaches without causing undue harm or trauma.
Okay. Yes, the court is, of course, not ordering any witness to speak to investigators, but certainly they have that right and duty to reach out and conduct investigations. So in a moment, I will sign off on that pretrial protective order, and that will be sent over to the Weber County Jail to be served upon the defendant in this case. All right. Where he is in custody currently, obviously he does have the right to his preliminary hearing within 14 days. I know the allegations here are extremely serious, and it may take some additional time potentially to be prepared for that preliminary hearing. Mr. Nish, would he like to set that preliminary hearing now, or would he waive time to conduct additional investigation before conducting that important hearing?
We'll waive that time, Your Honor. We need to receive discovery and get to work first.
All right. Would you like to set a decision for preliminary hearing out a couple weeks?
Your Honor, let's set a decision to prelim out a couple of months if the court will indulge us. It's going to take some time to really get our feet under us in this case.
Mr. Wardle, any objection to finding a time for a decision to prelim in a couple of months? That way the defense can be able to make their discovery request and start their investigation.
No, that makes sense.
What about October 23rd at 9 a.m.?
That works, Your Honor.
And I'm sorry, Your Honor, I actually will be unavailable that day.
That's okay. What about the 30th of October? That's a Thursday.
That works for me.
Okay. Now, counsel, how would you like to go about that? Obviously, we had some technical difficulties today, but we were able to work through those. Do you want the decision to preliminary hearing to take place in person or via WebEx? I'm amenable to both approaches.
WebEx would be preferred for the defense.
And for me, I can do either one, Your Honor, so I'll defer to you and counsel.
And I wasn't able to hear what you said. Would you prefer WebEx?
Prefer WebEx, Your Honor.
Okay. All right. Given that, let's have the decision to preliminary hearing take place October 30th at 9 a.m. That will take place via WebEx, and the defendant will appear from the Weber County Jail at that time. Let's start first now with Mr. Wardle. Is there anything else that needs to be addressed here today at this initial appearance?
No, I just wanted to talk about that pretrial protective order, so I appreciate you being proactive with that. I don't think I have anything else.
Mr. Nish, anything from the defense's point of view?
Just to put the court on notice, we will file our entries of appearance, our affidavits of Rule 8 qualification, as well as a proposed order appointing Ms. Corporon and I to the case this afternoon. I'll probably also file a motion just for the court's consideration, ordering the defense team to have contact visits with our client at the Weber County Jail.
Fair enough. I'll look for that in my queue and I'll get those signed. In accordance, one last thing I failed to mention, in accordance with Rule 7 of the Utah Rules of Criminal Procedure, at the defendant's first appearance, I do need to inform him that at this hearing and that at future hearings, he is not required to make any statement, and any statement that he makes in open court could be used against him in a court of law. So I wanted to make sure he's aware of that important constitutional right.
Thank you.
All right. Anything further to address today before we conclude the hearing?
Not from the defense.
No, thank you, Your Honor.
All right. Thank you all for being here today. Court is in recess.